Some people have asked me recently why the conviction rates in certain offences are so very low. And whilst I obviously can't answer that question entirely, I thought in this video I would give a broad outline as to the reasons why prosecutions themselves can be very difficult and why in certain offences the conviction rates that follow from prosecutions may be very low in certain cases. And to do that, I thought I would give you a broad overview, starting with the CPS, that is the Crown Prosecution Service, that is the public prosecutor. There are two types of prosecutions, broadly speaking. There are public prosecutions and private prosecutions. A private prosecution may be brought by an individual, or it may be brought by a company. Private prosecutions may well be a company prosecuting one of its employees, let's say for stealing company material. But in either case, the CPS may take over any private prosecution and either continue the prosecution and run it, or indeed bring it to a close and shut it down. But for the purposes of this video, I'm going to talk about the process of a prosecution, the decisions that are made, and then things that can affect a prosecution along the way. Starting with some broad principles, the CPS as a prosecutor is independent from other persons and other agencies. In other words, it stands as an independent body to prosecute cases on behalf of the Crown. It is not the role of the CPS to determine whether or not a person is guilty as charged of an offence, rather to make an assessment as to whether to present such a case to a court to consider. And in considering every case and making its decisions, the CPS will have regard to what's known as the Code for Crown Prosecutors. And within it, there is what is known as a full code test, which is a two-part test. And subsequently, there is a threshold test, but I will come back to that a little bit later. The two-part test, which makes up the full code test, first begins with an evidential stage. This is essential in all but very few cases where the second part is considered, but again, I'll come back to that later. Primarily for the evidential stage, prosecutors must be satisfied that there is sufficient evidence gathered during the investigative stage of a case for a realistic prospect of a conviction against each and every suspect and against each and every charge on the indictment. And in each case, the CPS must consider what the defence case is likely to be and what effect that is likely to have on the prospects of a conviction. The default position is that a case that does not satisfy this evidential stage and test must not proceed to prosecution, however serious or sensitive the case might be. So for the next few elements, when I talk about the evidential stage, when considering offences that are of a much more serious nature, I urge you to think about how the scope of each of these elements might increase, perhaps in proportion to the seriousness of the offence, and doubtless the age and nature of the offence itself. One of the first things prosecutors will consider is whether or not the evidence can be used in court, which might sound obvious. But there are, of course, various elements that might make key pieces of evidence inadmissible in court, and therefore may have an impact on the prospects of a conviction, thus a big dent in the evidential stage test. Another important element is the reliability of the evidence itself, which is not just down to from whom or which machine the evidence came from, but perhaps how old it is, whether it's been tampered with, influenced, and so on. In part of this consideration, it will also be considered how credible that evidence is likely to be. And part of this is whether the evidence is likely to remain credible during a trial. Because as with any trial, evidence is going to be challenged. So that means for very sensitive cases, when evidence is produced in court, it is going to be challenged robustly by a robust and vigorous defence. Because as you often hear me say on this channel, cases must be prosecuted and defended just as fiercely and just as fairly. Otherwise, by default, it would be a corrupt system. So it must be equally fought on both fronts. So every piece of evidence that is brought to trial by a prosecutor is going to be quite rightly challenged by the defence counsel. One obvious consequence of this, however, is that for particularly sensitive cases, witnesses that come forward with very difficult evidence to give may be challenged robustly and find it difficult to give that evidence convincingly. And whilst this of course does not necessarily invalidate that evidence, but it is something that prosecutors must consider and which will ultimately have an effect on the conviction rates of certain offences. If a case satisfies the evidential stage of this test, then the prosecutor must go on to consider whether or not a prosecution is in the public interest. But it has never been the case that a prosecution will automatically take place just because the evidential stage has been satisfied. Prosecutors will therefore go on to consider the seriousness of the offence, the culpability of the suspect, any harm caused to the victim, various other elements regarding the suspect, the impact that such offences have on the community, and whether or not a prosecution is a proportionate response, among other things. And as I said earlier, in all but very few cases, both stages of this test must be met before a prosecution takes place, save for those few where the full test is not met and a threshold test is applied instead. This is usually when the offence is so serious and there are various conditions that must be met to meet the threshold test. And so with that in mind, I turn to the second part of the discussion, which is a general discussion on the nature of a criminal prosecution itself. You see, for the most part, a criminal case should be seen as being very different from a civil case because liberty is at stake. Because whilst in some civil cases there can be a limit on freedoms such as a mandatory injunction or prohibitory injunction or some other kind of restraining order, a successful prosecution resulting in a conviction will very often end in a custodial sentence. And as a society, if we are going to support a custodial sentence upon a convicted defendant, those decisions must be the right ones. Accordingly, the burden of proof in the criminal courts is different than it is in the civil and family courts, that is, beyond a reasonable doubt, or as it is now put to a jury, so that the jury must be sure of the finding of fact that they are making. And it is right to say that in some of the most serious offences, there is a significant subjective element that we ask a jury to decide. That might be knowing something, not knowing something, intending something, or not intending something. And a jury is asked to make this determination based on what an individual was thinking or knew at that time. Defence counsel will doubtless be saying to a jury that if they are not absolutely sure of any given fact that they are asked to decide, such as what the defendant was thinking at the time, then they must not convict the defendant of the offence. So ultimately, the more serious the offence, the more evidence there is to consider, and the more subjective elements a jury is invited to make a finding on, the more difficult it will become for a jury to convict. So I hope this video serves as a useful overview as to how prosecutions are brought in the first place, and the elements that the CPS need to consider when making the decision to charge and to prosecute, and in turn the elements that make it difficult for a jury to convict a defendant given so many subjective elements that may go back some time and based on very individualized accounts of what transpired. Please do give this video a thumbs up if you find this content useful, and remember, stay humble and subscribe.